It wouldn't be constitutional to punish someone for their thoughts. After all, you probably think about committing a criminal offense every so often, like fantasizing about punching your neighbor who plays his music too loud in the middle of the night. At the same time, the Texas Penal Code recognizes that there are a few specific crimes that we need to have the means to interrupt before they actually happen, particularly when someone is serious enough about committing them to ask another person to help. The Penal Code states the in-choate offense of criminal solicitation is committed by a person who, with intent that a capital felony or felony of the first degree be committed, requests, commands, or attempts to induce another to engage in specific conduct that would constitute a felony or make them a party to the offense. Again, criminal solicitation applies only to capital felonies or felonies of the first degree, only the very most serious crimes. To place a safeguard on trying to prosecute someone for their mere thoughts or even just their mere words, the Penal Code states a person may not be convicted under this section on the uncorroborated testimony of the person allegedly solicited except under very certain circumstances. So, the sole evidence against a person in an in-choate solicitation case can't just be that they asked someone to help them commit a capital felony or felony of the first degree. There has to be other evidence as well. Similar to criminal conspiracy, the Penal Code states it is no defense the person who was solicited is not criminally responsible for the felony solicited, or has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense or of a different type or class of offense, or is immune from prosecution. Once again, you are on your own when it comes to a conspiracy charge, regardless of what happened to the person whom you asked to help you commit the capital felony or felony of the first degree. Also similar to criminal conspiracy, it is no defense the actor belongs to a class of persons that by definition of the offense is legally incapable of committing the offense. This would apply if the person you solicited is a juvenile who is not permitted under law to be charged as an adult or turns out to be an undercover officer posing as a hitman. So this section prevents a defendant from claiming they can't be charged with solicitation because it requires two persons and either the juvenile is legally incapable of being held responsible as an adult or the peace officer wasn't charged. It is also not a defense to solicitation that the felony solicited was actually committed. Once again, it may be difficult to prove the offense was committed in a court of law, but much easier to prove solicitation beyond a reasonable doubt. For example, a husband solicits his girlfriend to murder his wife. The girlfriend puts poison in the wife's glass, and the wife dies. Both the husband and girlfriend are caught. The girlfriend is charged with capital murder. But due to the complexities of the case, the prosecutors don't believe they can prove the murder charge on the husband beyond a reasonable doubt. He is instead charged with solicitation to commit capital murder, even though they could have also charged him with capital murder. At his trial, the husband cannot claim that he cannot be charged or convicted with solicitation to commit capital murder because the capital murder was actually committed. Finally, solicitation offenses are charged one level lower than the offense solicited. So if a capital offense is solicited, then it's punished as a felony of the first degree. And if a felony of the first degree is solicited, it's punished as a felony of the second degree.